Before most Americans even woke up that morning, the Supreme Court quietly changed how power works in the United States. No warning, no public debate, no televised arguments. Just a sudden 6-3 emergency ruling that began affecting millions of people within weeks. And here's the part almost no one told you. This decision did not just alter a single policy or resolve a narrow legal dispute. It fundamentally changed how your rights are protected in this country. Whether you realize it or not, the legal ground beneath your feet shifted overnight. This is not just another Supreme Court headline. This is a tectonic realignment of power between judges, presidents, and the American people. In state capitals, federal agencies, and courtrooms from Washington, D.C. to California, the rules of the game were rewritten in a matter of hours. And most people have no idea what actually happened. I've spent years analyzing constitutional law, federal court decisions, and the balance of power between our three branches of government. And I can tell you that what the Supreme Court did in Trump versus CASA Incorporated is one of the most consequential legal decisions of the last 50 years. It is not hyperbole. It is not partisan spin. It is a fundamental restructuring of how American courts can protect American citizens from government overreach, and the consequences are already unfolding in real time. Let me walk you through exactly what happened, why it matters, and what it means for you personally. Because this ruling does not just affect lawyers and activists and politicians. It affects anyone who has ever relied on a federal court to protect their rights. It affects anyone who has ever believed that the Constitution means the same thing in Texas as it does in California. It affects anyone who thought that when a law is unconstitutional, it is unconstitutional everywhere. That assumption, that bedrock principle of American justice, just got demolished. Late one night, in June 2025, the Supreme Court released a 6-3 emergency ruling in Trump versus CASA Incorporated through what is known as the shadow docket. That means no oral arguments, no months of deliberation, no full public briefing, just a rapid decision that immediately reshaped the legal landscape. The case itself involved a high-stakes executive order tied to birthright citizenship. But the court used this case to do something much bigger. It settled a decades-long internal war over judicial power that had been quietly building behind the scenes. At the center of this ruling is a concept most Americans have never heard of, but have relied on for decades: nationwide injunctions. The Supreme Court just ruled that federal judges can no longer issue universal injunctions that block a law or policy from being enforced across the entire country. And while that may sound like technical legal language, the consequences are enormous. This single decision rewrites how constitutional challenges work in America. Let me explain what nationwide injunctions actually are, because understanding this is critical to understanding why this ruling matters so much. For the last 25 years, when someone challenged a law they believed was unconstitutional, a single federal judge could temporarily stop that law from being enforced anywhere in the United States while the case worked its way through the courts. One judge, one courtroom, one order. And the entire federal government had to hit pause nationwide. That power was used in immigration cases, healthcare disputes, environmental regulations, gun laws, workplace rules, voting procedures. A judge in California could freeze a policy in Texas. A judge in Texas could block a rule from taking effect in New York. That era is now over. The Supreme Court did not just limit that power, it destroyed it. Think about what that means for a moment. Before this ruling, if the president signed an executive order that violated your constitutional rights, you could sue in federal court. And if you won, if the judge agreed that the policy was unconstitutional, that judge could stop the entire federal government from enforcing that unconstitutional policy against anyone, anywhere. That is how constitutional protections worked. That is how the system maintained uniformity. That is how one constitution applied equally to 330 million Americans. Now here is what happens instead. If you sue and win, the judge can only protect you, not your neighbor, not your coworker, not the millions of other Americans affected by the same unconstitutional policy. Just you and the other named plaintiffs in your specific lawsuit. Everyone else, they have to file their own case in their own district before their own judge. And hope they win too, if they can afford to sue at all, if they even know they need to. According to court filings reviewed the morning after the ruling, there were 68 active nationwide injunctions affecting everything from prescription drug access to workplace safety and election administration. Under this new framework, many of those injunctions could collapse within the next 60 to 90 days as lower courts scrambled to revise their orders, and the timing could not be more explosive. We are heading straight into an election year with major fights over immigration, healthcare, civil rights, and voting rules. This ruling just changed how every single one of those battles will be fought. Let me give you the numbers because the numbers tell a story that politicians on both sides do not want you to hear. During President George W. Bush's entire administration, courts issued approximately 2 nationwide injunctions. Just 2. During President Obama's 8 years, that number jumped to 12. Still relatively modest. Then came Trump's first term from 2017 to 2021. The number exploded to 64 nationwide injunctions, more than all previous administrations combined. Under President Biden, the count dropped to 14. But here is where it gets extraordinary. Within just the first few weeks of Trump's second term in January 2025, judges had already issued more than 68 nationwide injunctions, blocking various administration actions, more in weeks than Bush saw in 8 years. Now you might hear that statistic and think one of two things. Either you think this proves that liberal judges were abusing the system to block a conservative president, or you think this proves that the Trump administration was issuing so many constitutionally questionable orders that courts had no choice but to intervene. Both sides have their narrative. But here is what the numbers actually tell us. They tell us that presidents have been relying more and more heavily on executive orders to advance major policy goals. And the more executive power expands, the more courts felt compelled to check it. Nationwide injunctions became the judicial system's primary tool for maintaining constitutional boundaries. And now that tool is gone. The majority opinion was written by Justice Amy Coney Barrett and joined by Chief Justice Roberts, along with Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their argument rests on a simple but radical claim. The Judiciary Act of 1789 never gave judges the authority to protect people who were not actually parties to a lawsuit. According to the majority, a judge's role is to resolve specific disputes between specific people, not to act as a nationwide veto over presidential or congressional action. Justice Barrett applied what has become the court's dominant interpretive methodology, originalism, the view that constitutional and statutory meaning should be fixed at the time of their enactment. She wrote that federal courts' equitable authority derives from the Judiciary Act of 1789, which granted courts only those remedies that existed in the English Court of Chancery at the founding. Because nationwide injunctions had no equivalent in 18th century English or early American practice, Barrett concluded, federal courts lack authority to issue them today. She emphasized, and I quote, "Nothing like a universal injunction was available at the founding, or for that matter, for more than a century thereafter." The majority found that nationwide injunctions were not a feature of federal court litigation until sometime in the 20th century and remained rare until the turn of the 21st century. Under this originalist framework, the recency of the practice was fatal to its constitutionality. In other words, because judges in 1789 did not issue these kinds of broad injunctions, judges in 2025 cannot either. The Constitution froze in amber, and modern remedies for modern problems are now unavailable. But the most explosive reasoning did not come from the main opinion. It came from Justice Gorsuch's concurring opinion. He traced court practice from the founding era through the late 1800s and found something remarkable. American courts did not issue injunctions protecting people who were not directly involved in the case. Judges repeatedly refused to extend relief beyond the actual plaintiffs standing in front of them. Justice Thomas went even further, arguing that nationwide injunctions are a modern invention that encourages forum shopping, where advocacy groups hunt for sympathetic judges to shut down policies they oppose. According to the majority, that era is now officially over. Now let me tell you what the dissenting justices said, because this is where the full weight of this decision becomes clear. Justice Sotomayor authored a 26-page dissent joined by Justices Elena Kagan and Ketanji Brown Jackson. She read her dissent from the bench. That is extraordinarily rare. That is a justice telling the public in the most dramatic way possible that something has gone profoundly wrong. Sotomayor did not challenge the majority's historical analysis. Instead, she reframed the entire discussion around substantive constitutional rights. She emphasized that every judge to review Trump's birthright citizenship order, judges appointed by presidents of both parties, had concluded it was, and I quote, patently unconstitutional. Under the majority's rule, Sotomayor warned, these constitutional violations could proceed against non-parties, leaving millions of Americans unprotected unless each individual sued separately. Let me read you her exact words. The court's decision to permit the executive to violate the Constitution with respect to anyone who has not yet sued is an existential threat to the rule of law. That is not partisan rhetoric. That is a sitting Supreme Court justice warning the American people that constitutional rights are now conditional. They depend on whether you can afford a lawyer, whether you know to file a lawsuit, whether you happen to live in the right district with the right judge.
Sotomayor articulated the practical absurdity. If birthright citizenship protections depend on whether someone has filed a lawsuit, then the 14th Amendment protects only those with resources to litigate. This creates a system where constitutional guarantees become meaningful in name only for any individuals who are not parties to a lawsuit. Think about that. Your constitutional rights now depend on your bank account and your zip code. Justice Ketanji Brown Jackson filed a separate dissent that fundamentally challenged the majority's originalist framework. She argued that the question, may a federal court in the United States of America order the executive to follow the law, is more basic and more important than whether nationwide injunctions existed in 1789. Jackson called the majority's focus on historical precedent a smokescreen that obscured this fundamental principle. She raised hypothetical but plausible future scenarios. Under the court's decision, an administration could seek to seize firearms or ban certain religions. Without nationwide injunctions, a court protecting religious liberty for a mosque in one district could do nothing to protect temples or churches in others, unless each separately sued. Similarly, if an administration attempted to strip voting rights from a disfavored group, nationwide relief would be unavailable. Individual voters would need to sue district by district, an enormous collective action problem that would inevitably leave millions unprotected. Now here is where I need you to understand the stakes in concrete terms. Let me walk you through what happened within 48 hours of this ruling. The legal landscape shifted dramatically. Attorneys general from 18 states filed emergency motions in federal courts attempting either to preserve existing injunctions or to immediately enforce laws that had been frozen for years. Texas moved aggressively. 2 narrow injunctions blocking immigration enforcement. Florida filed emergency briefs targeting social media regulations and election procedures. California and New York countered with filings of their own, desperately trying to preserve nationwide blocks on federal policies they oppose. Behind the scenes, the Department of Justice convened emergency strategy sessions with hundreds of federal attorneys across dozens of active cases. The White House counsel's office quietly warned federal agencies to prepare for laws they believed were blocked to suddenly take effect, possibly within weeks. The speed and scale of the reaction tells you everything. Legal strategists view this as a massive power shift toward the executive branch and a devastating blow to judicial resistance. Advocacy organizations on both sides of the political spectrum are now scrambling. Groups like the ACLU, Knock Legal Defense Fund, and Alliance Defending Freedom relied on nationwide injunctions as their most powerful legal weapon. That weapon is now gone. Major law firms are warning clients that civil rights and constitutional litigation could now cost 5 to 8 times more. Because instead of filing one lawsuit, plaintiffs may need to file in dozens of jurisdictions. Let that sink in. The cost of defending your constitutional rights just increased by a factor of 5 to 8. Let me show you what this looks like in practice across different areas of American life, because this is not abstract theory. This is already happening. Immigration enforcement is ground zero. There are currently 19 injunctions limiting ICE practices nationwide. Under the new framework, those protections may only apply to specific plaintiffs in specific districts. Immigration enforcement could now look completely different depending on where you live. An immigrant in Maryland, where the original birthright citizenship lawsuit was filed, might have judicial protection against certain ICE enforcement practices. An identical immigrant in Texas might have no such protection. ICE officials must now determine for each enforcement action which district's injunction, if any, applies. Inconsistent enforcement inevitably follows. One family protected, the next family deported. Same circumstances, different zip code. Healthcare is fragmenting just as rapidly. Approximately 68 nationwide injunctions protect healthcare access, including access to abortion, medications like mifepristone, and gender-affirming care for transgender individuals. The end of nationwide injunctions means a woman seeking medication abortion in California might have judicial protection. Her counterpart in Oklahoma might not. A transgender teenager in Maryland might have access to hormone therapy protected by court order. A teenager in Texas might not. Pharmaceutical companies must now track which treatments they can sell in which districts, complicating supply chains and increasing costs. Doctors must understand fragmented, district-by-district legal standards for what procedures they can safely perform. Public health scholars warn that this fragmentation will create treatment deserts, regions where certain care becomes legally unavailable or economically unviable to provide. One constitution, 50 states, 94 federal districts, and your access to healthcare now depends on geography more than medicine. But here is what keeps election law experts up at night. One of the most alarming consequences involves elections. Nationwide injunctions currently protect voting procedures, mail-in ballot rules, and election administration standards. With that protection gone, one state might allow mail-in voting protected by a narrow injunction. For named plaintiffs, another state with different plaintiffs might enforce restrictions against the broader population. Federal standards for ballot counting, poll access, or voter registration might be enforced differently depending on the district. Election administrators face compliance nightmares. Which federal rules apply in my county? Which district's court orders bind my office? Corporate election vendors must support radically different voting systems across different regions. Election law experts warn this could produce the most chaotic election cycle in modern U.S. history, particularly for the 2026 midterms. And those midterms are happening right now. The legal chaos is not hypothetical. It is the reality election officials are navigating as we speak. Corporate America is also panicking. Multi-state companies are now facing the prospect of complying with different federal rules in different regions. Banking, healthcare, technology, and pharmaceutical industries are all warning of massive compliance costs and regulatory confusion. Estimates suggest this legal fragmentation could cost businesses tens of billions of dollars annually. That is not speculation. That is CFOs across America calculating what it means when federal law exists on paper but is enforced differently across the country. A company operating banking services might face completely different regulatory standards by district, making cross-state operations complex. Hospitals and insurers must navigate fragmented standards for covered treatments. Social media platforms must enforce different content moderation standards by region. Drug approval and availability vary by district. The unified American market, the economic foundation of the world's largest economy, is being fractured by legal inconsistency. Now let me address something that the majority opinion completely ignores: the shadow docket. The Supreme Court decided this case through an emergency procedure that allows the court to issue orders without full briefing, oral arguments, or detailed written opinions. This is not normal. This is not how consequential constitutional questions are supposed to be resolved. Justice Elena Kagan and other critics have warned that the shadow docket has become increasingly weaponized. Between 2017 and 2025, the court granted relief on the shadow docket far more frequently than in previous decades. As Kagan wrote in dissent from another shadow docket decision, our emergency docket should never be used, as it has been this year, to permit what our own precedent bars. Still more, it should not be used, as it also has been, to transfer government authority from Congress to the president, and thus to reshape the nation's separation of powers. Think about what that means. The Supreme Court is using emergency procedures, designed for genuine emergencies requiring immediate action, to make sweeping constitutional decisions without the deliberation that such decisions require. No oral arguments where justices can probe the weaknesses in each side's position. No full briefing where the implications can be thoroughly examined. No time for the legal community and the public to understand what is at stake. Just a rapid decision issued in the middle of the night that fundamentally restructures federal power. The case received no oral arguments. The parties' written briefs were limited, and the majority opinion, while 26 pages, lacks the depth of reasoning expected for such a consequential ruling. Constitutional scholars across the political spectrum are alarmed, not just at the outcome, but at the process. When the highest court in the land makes its most important decisions through its least transparent procedures, something has gone wrong with judicial accountability itself. Let me draw a historical parallel that makes the stakes of this ruling unmistakably clear. In the 1950s and 1962, federal courts issued nationwide injunctions protecting civil rights. They enjoined school segregation nationwide after finding it violated the Equal Protection Clause. If nationwide injunctions had been unavailable then, civil rights advocates would have needed to file suit in every district, in every state, seeking district-by-district relief. The uniformity of the civil rights revolution would have been impossible. A fragmented, uneven expansion of rights would have resulted instead. Imagine Brown versus Board of Education, but instead of ending school segregation nationwide, it ends school segregation only for the specific plaintiffs in Topeka, Kansas who actually sued. Meanwhile, black children in Alabama, Mississippi, Georgia, and every other state would still face segregated schools, unless their parents could afford lawyers, unless they could find sympathetic judges, unless they had the resources to litigate for years while their children grew up in inferior schools. That is the America we could have had, and that is the America we are returning to. Not because the Constitution changed, not because the law changed, but because the Supreme Court decided that the remedies courts developed to make the Constitution meaningful are too modern, too innovative, too effective to survive. Now here is where I need to address the other side of this argument, because intellectual honesty demands it. Conservatives have long complained about forum shopping. They argue that progressive advocacy groups deliberately file lawsuits in federal courts with judges they believe are sympathetic to their cause. A coalition of immigrant rights organizations might file a challenge to an immigration executive order in the U.S. District Court for the District of Maryland or another jurisdiction known for issuing broad relief. Once one sympathetic judge issued a nationwide injunction, the same policy would be blocked across all 50 states, even in districts where judges might have ruled differently. There is truth to this critique. Forum shopping does occur, but here is what that critique ignores. Conservative groups forum shop just as aggressively. During the Obama and Biden administrations, Republican attorneys general filed challenges in the most conservative federal districts they could find, courts in Texas and Louisiana, that were equally sympathetic to their legal arguments. The Supreme Court did not ban nationwide injunctions to end forum shopping. It banned them when the tool was being used most effectively against a Republican administration. The timing tells you something the legal reasoning does not. Moreover, defenders of nationwide injunctions noted that judges appointed by both Republican and Democratic presidents had issued orders blocking Trump administration actions. This suggests that the decisions reflected legal principle rather than partisan motivation. When a president attempts to strip birthright citizenship, ban certain religions, or fundamentally alter immigration enforcement nationwide, a judge limited to protecting only the named plaintiffs would leave millions of Americans unprotected. But let me tell you about the workarounds, because the legal system is nothing if not creative. Justice Samuel Alito noted in a concurring opinion joined by Justice Thomas that nationwide injunctions might return through the back door via class action litigation. Under Federal Rule of Civil Procedure 23, a court can certify a nationwide class if the class satisfies requirements of numerosity, commonality, typicality, and adequacy of representation. A certified class judgment would bind all class members nationwide. Ironically, shortly after Trump versus CASA, the immigrant advocacy organization itself, filed a motion for nationwide class certification in the birthright citizenship case. On July 10, 2025, the Maryland federal court certified a nationwide class, potentially restoring relief that the Supreme Court had just eliminated. If this approach succeeds, Justice Alito warned, the universal injunction will return from the grave, negating the Supreme Court's intended effect. But class certification is not a perfect substitute. It takes time, it costs money, it requires meeting strict legal requirements that not every case can satisfy. And while class actions work through the system, unconstitutional policies continue to be enforced against millions of people who are not yet class members. The damage accumulates. While the lawyers litigate, state courts remain another avenue. Because Trump versus CASA applies only to federal courts deciding federal questions, state courts remain largely unaffected. State attorneys general may continue to seek broad relief in state courts against state defendants or, in some circumstances, against federal officials. This could prove crucial. A coalition of states might obtain a statewide injunction in state court that effectively reaches nationwide scope, particularly in large states like California or New York. District courts are also experimenting with narrower injunctions that, while technically party-specific, extend to broad categories. For instance, instead of enjoining a policy nationwide, a court might enjoin it against all members of the plaintiff organization nationwide or all residents of this state. These formulations technically comply with the Supreme Court's holding while maintaining broad reach. Whether the Supreme Court will tolerate these creative interpretations remains to be seen. But here is the fundamental problem that no workaround can solve. The Trump versus CASA ruling fundamentally shifts power toward the executive. When a president issues a nationwide executive order, all federal agencies must follow it uniformly. It has nationwide force by definition. But when courts issue injunctions, they can no longer match that nationwide scope unless they navigate the narrow pathways of class actions or state litigation. This asymmetry means the president can act nationwide in a single order. Courts can only block that action narrowly through multiple litigation. The executive's unilateral power exceeds the judiciary's counterpower. Constitutional theory has long emphasized that separated branches should have roughly equal power to check each other. The Trump versus CASA decision disrupts that equilibrium, tilting it toward the executive. This is not a partisan observation. Conservative legal scholars have made the same point. The issue is structural. When one branch can act with nationwide force and another cannot respond with equivalent force, the balance of powers shifts, and once that balance shifts, it tends to stay shifted until a constitutional crisis forces a correction. Justice Barrett's opinion suggests that if Congress disagrees with the court's interpretation of equitable authority, it can amend the Judiciary Act to explicitly grant courts authority to issue nationwide injunctions. That is technically true, but in the current political environment, with Republican control of Congress and alignment with the Trump administration's position, such an amendment is effectively impossible. And even if Democrats regained control, any amendment would face presidential veto. The court's solution requires a political alignment that does not exist and may not exist for a generation. As of late January 2026, approximately 6 months after Trump versus CASA, the predicted consequences are materializing. Lower courts have narrowed or allowed collapse of many nationwide injunctions. Some district judges have issued new, narrower orders protecting specific plaintiffs. Others have allowed enforcement to proceed, pending further legal proceedings. The process is chaotic, with different courts taking different approaches, creating exactly the fragmentation critics predicted. The 68 nationwide injunctions identified in summer 2025 have been steadily narrowed, challenged, or replaced. Immigration advocates report that ICE enforcement has become more aggressive and geographically inconsistent. Healthcare providers face unclear legal standards. Election administrators express deep concern About the 2026 midterms, the chaos is not coming. The chaos is here. In April 2025, the House passed the No Rogue Rulings Act, a bill designed to legislatively codify the Supreme Court's holding that nationwide injunctions exceed judicial authority. The bill passed 219 to 213 on a party line vote. Democrats characterized it as endorsing unconstitutional executive overreach. Republicans framed it as preventing judicial activism. The legislation crystallized the partisan divide. One side sees nationwide injunctions as a tool for judicial activism that allows unelected judges to override democratically elected officials. The other side sees them as the last line of defense against executive overreach that protects constitutional rights for everyone, not just those who can afford to sue. Now let me leave you with this. I have studied constitutional law for years. I have watched Supreme Court decisions reshape American life in ways both subtle and dramatic. And I can tell you that Trump versus CASA is not a routine case. It is not a technical adjustment to federal procedure. It is a fundamental restructuring of how American courts can protect American citizens, and the people who will suffer most are not lawyers or politicians or advocacy groups. They are ordinary Americans who cannot afford to file their own federal lawsuits. They are people who assumed reasonably that if a law violated their rights, they could rely on someone else's court victory to protect them too. They are people who believed that constitutional rights meant the same thing everywhere, that belief was reasonable. It was correct for 25 years, and now it is wrong. Your rights may now depend on your zip code. Your access to healthcare may now depend on which federal district you live in. Your voting procedures may now depend on whether someone in your specific county filed a specific lawsuit before a specific judge. Your immigration status may now depend on whether you can afford the litigation that your neighbor cannot. We are entering an era where federal law exists on paper but is enforced unevenly across the country. 50 versions of the same law, one constitution, but fragmented protection, whether this represents a return to constitutional originalism or a dangerous fragmentation of justice depends on your perspective. But one thing is certain, the legal patchwork is here, and its consequences will define immigration policy, elections, civil rights, and economic stability for years to come. The Supreme Court's 623 emergency ruling in Trump versus CASA did not just change a legal procedure. It changed the meaning of protection in America. If your right to vote, to equal protection, or to due process only exists if you personally have the resources to sue, then those rights begin to look less like guarantees and more like privileges. I want to ask you a question, and I want you to think about it seriously. If a future president signs an executive order that violates your constitutional rights, what can you do about it? Before Trump versus CASA, the answer was relatively simple. You could join a lawsuit, support an advocacy organization, or simply wait for someone else to challenge the order in court. If they won, you won. The unconstitutional policy stopped. You were protected even if you never hired a lawyer, even if you never set foot in a courtroom. Even if you did not know your rights were being violated until the court told the government to stop, that is no longer true. Now, if you want protection, you have to sue personally in your own district, before your own judge, and you have to win your own case. If you lack the resources, the knowledge, or the access, then the constitutional violation continues against you, even if 100 other courts have found it unconstitutional. Even if the Supreme Court itself later rules the policy illegal, until you personally obtain relief, you personally remain unprotected. This is what the dissenting justices meant when they called this ruling an existential threat to the rule of law. Not because they were being dramatic, not because they were playing politics, but because the rule of law means something specific. It means that when a government action is illegal, it is illegal for everyone. It means that constitutional rights are not rationed. They do not depend on wealth or location or legal sophistication. They apply universally because they are universal rights. Trump versus CASA defines what universal means. It says the Constitution applies everywhere, but judicial enforcement can only reach the specific people who manage to get themselves before a specific court. It is universality in theory, but fragmentation in practice. It is a constitution that means one thing and a remedial system that delivers something entirely different. If you found this analysis valuable, make sure you are subscribed because this is exactly the kind of Supreme Court decision that does not feel real until it hits your life directly. And when it hits, when you discover that your rights depend on whether you can afford to assert them, when you learn that the court victory in another district does not protect you. When you face the reality that constitutional guarantees have become constitutional suggestions, you will want to understand how we got here. The shadow docket moved in darkness, the legal ground shifted overnight, and the country woke up to a new constitutional reality that most people still do not fully understand, but you do now. You know what happened. You know why it matters. You know what it means for immigration, healthcare, elections, and the fundamental principle that in America, no one is above the law and everyone is equally protected by it. That principle took a devastating blow in June 2025. Whether it recovers depends on what happens next. Whether it recovers depends on Congress, on state courts, on advocacy organizations, on class action litigation, on the 2026 elections, on the Supreme Court's willingness to revisit its own precedent, on the American people's understanding of what they lost and their determination to get it back. I am not here to tell you how this story ends. No one can predict that with confidence, but I am here to tell you that this story is far from over. The legal battles have just begun. The constitutional crisis is unfolding in real time, and the outcome will shape American justice for a generation. Was the Supreme Court right to end nationwide injunctions? Or did it fracture the rule of law? Your answer may say more about the future of America than you think, and your actions, your votes, your engagement with the system may determine whether constitutional rights remain rights at all, or whether they become privileges available only to those who can afford to defend them. This is the new reality. This is the new constitutional order. And this is the moment to understand exactly what it means, because the next time your rights are on the line, there may be no one else's court victory to protect you. There may be just you alone in a system that now requires you to fight for yourself. The question is whether you will be ready. The question is whether America will be ready for what comes next. The legal ground has shifted, the power has realigned, and the consequences will echo through every courtroom, every polling place, every hospital, every community in America for years to come. This is not the end of the story. This is the beginning. And if you want to stay ahead of these changes, if you want to understand the forces reshaping American law, make sure you are subscribed, because what the Supreme Court did quietly, in the shadows, in the dead of night, will be felt loudly, in broad daylight, by millions of Americans who are only beginning to understand what they lost.